The next important topic is immoral. Immoral means what? What is morality? What is ethics? Broadly speaking, so far as morality is concerned, under law, morality is viewed only as ethics. So let us not actually go into the question, what is the difference between morality and ethics, sir? As I told you, what is considered to be morality may not be ethical. What is ethical may not be moral. See, these are matters which are considered to be very, very relative, and we have got to look at it from the point of view of benefit to the society. Then now let us take immoral. Why immoral? You see, society must be able to grow in a healthy condition. If what is considered to be injurious to the society and it is harmful to the society, then law will not permit. That is why I told you Judge Cardozo's beautiful opinion, his statement, legal justice, when divorced from ethical concept, tends to become tyrannical and the fruitful parent of injustice. So, any law that is enforced must be ethical. What is morally authorized may not be ethical. Immersion of Lord Ganesha into the tank is considered to be a moral code, but it is not beneficial to society. You are polluting the water. Immersion of ashes in the Ganges and Yamuna may be authorized under a moral code, but it is not ethical. It pollutes, it contaminates the river. Therefore, you have got to understand from the broad aspect. Now, let us actually analyze what are the circumstances under which an agreement is said to be immoral. An agreement is said to be immoral when it paves the way for society to indulge in immoral activities. For example, Pierce versus Brooke is a very famous case. There was a woman who was selling herself in order to eke out her livelihood. But there are circumstances where poor people, in order to eke out money, they are actually selling themselves. That is very bad. The law should actually be very stringent. Not only social institutes should come forward in order to protect these poor people from selling themselves. So here, there is a trafficking on human beings, on children and all that. That must be avoided under the Constitution. So the Constitution itself speaks about that, and it says the measures that are got to be taken to avoid this trafficking of children and women in society. Now, we have got this famous case, Pierce versus Brooke. In this particular case, a woman who used to attract people and sell herself by receiving money and all that, she happened to be a woman who was actually having coaches. So she entered into a contract with a coach builder, a person who used to construct the coaches. That is a sort of a cart with a lot of adorations and all. That is a lot of adornments and all that. She entered into a contract with a coach builder for constructing a coach. But the coach which she purchased, the price has got to be paid to the coach builder. She entered into a contract with him that she must be permitted to pay the lot of money, the entire sum of money, by way of equal installment. So the coach builder also agreed. But here, one essential thing you must know is that coach builder knew about the activities of this woman. He knew that this woman has been selling herself in order to eke out her money. For that purpose, he had actually chosen to make use of this coach. So this particular fact the coach builder knew. So when this woman actually paid money for some months, the installment, and for the balance month when she has not actually paid the installment, the coach builder filed a suit against the woman. Then the question arose whether he will be able to recover it. The court said no, because the coach builder knew for what purpose the coach has been made use of by this woman who happened to be a prostitute. So here the court will not allow such things. Ex nudo pacto, that you see, anything which is considered to be offense, which is considered to be not good for society, will not be permitted under law to be carried out. So if an offense has got to be committed, the law will not permit, the law will not keep itself silent. It will immediately come to the rescue of the persons being exploited. So here you cannot actually make profit out of a crime. That is the case of Pierce versus Brook. Then, as I told you, if there is any agreement which has got for its consideration future illicit cohabitation. Future illicit cohabitation means what? If a person wants to hire a woman in order to have her association on a place where he can actually enjoy his holidays and all that. So, if this is considered to be a sort of an illegal agreement based on immorality. So, any person who has got any agreement that has been made with a woman to have her association on a future date for the purpose of giving her any money for which an agreement has been entered into, well, that is considered to be based on immorality. It is not from the point of view of encouraging a healthy life in a healthy society. So, any agreement which has got for its consideration future is, but what about past illicit cohabitation? Namberumal versus Veeraperumal. There were two persons. They were actually behaved like friends in a particular society, in a club. It's a Freemason club, they actually moved as friends. But subsequently what happened, these have started ending up in mutual admiration. Then it actually ended in emotional integration. And then what happened? Both of them, they happened to lead a life of husband and wife, on account of which a child was born. Then this fellow who had been responsible for the birth of the child, he entered into an agreement with that particular woman, stating that he will pay a certain sum of money or settle some property in her favor. Now this is for any service that have been done by her. For the service that he has rendered, this fellow has promised to give some money. So this is why even under section consideration, when at the desire of the promisor, the promisee or any other person does or abstains, proposes to do or abstain, or done, he has already done, or abstain from doing anything, past also. Past cohabitation, you see, when it is not based on adultery, well, that is enforceable. A person who has actually been living with another woman, on account of which if children are born, the children have got to be maintained. So for the purpose of maintenance of these children, if he has entered into an agreement to settle some property, do you mean to say that agreement is not valid? Definitely it is valid. How the children have got to be maintained? Therefore, any agreement which has got for its consideration past illicit cohabitation, that is considered to be enforceable. That has been given as a decision in the famous case Namberumal versus Veeraperumal in Madras High Court. Then the next thing that is prohibited under the ground of immorality is separation between husband and wife. If they marry, the very purpose of marriage is for the purpose of leading a harmonious life. But if they enter into an agreement that we want to actually divorce after marriage, we will actually divorce after 2 years later. Probably it may be based on evasion of income tax. Many film actors and actors, they actually marry one day and the next day they actually, or a few years later, they divorce. Well, this is for so many people. Ingeniously, they actually engineer to plan as to how to they evade tax. If that is the reason, well, this agreement is not considered to be valid. It is definitely unlawful. So, any agreement entered into for the purpose of future separation. Because this will attract section 29. If you read section 29 under the contract, I and you agree that we will agree in future. What is this? Very uncertain, isn't it? You agree at present, that you agree later. So that is, agreement for an agreement is considered to be vague. And section 29 will agree. Here is an agreement for future separation. Well, that is also not considered to be correct. So this is considered to be based on immoral. Then any agreement which is based on transaction which is opposed to public policy. What is public policy? Public policy means common good. Anything which is detrimental for the health and hygiene, for the peace, tranquility and harmony of society must be ruthlessly curbed. So this public policy cannot be defined. It is something like a wild horse. When once you go astray, we do not know where it will land. It's a wild horse. So you cannot define. So in one case, it was said the judges are there to expound law and not to expand law. There is a lot of difference between expounding law, expanding. See, if you ask, define a public policy, judge said, no, I cannot define a public policy. You bring a case before me, I will tell you whether it is opposed to public policy or not. You cannot ask me to define. See, the judge, he is also correct. See, can you define death? You must experience. When once you experience death, you are no longer there to explain it, isn't it? Likewise, sweetness. For example, sweet. Sir, this is very sweet, sir. See, define sweet. Define marital life. Marriage and then suffer, and then you can be able to explain, because every case law will be able to define what is what. So that is why the judge said, I cannot expound law, but I can. So the other jurist, he said, don't expand law, because it varies from case to case. If you start defining opposed to public policy means, the definition of public policy depends upon the facts and circumstances of the case. Therefore, it will be going on elaborating it. Judge will be going on elaborating it. That is why the judges are there only to expound law and not to expand law. That is what they said. Now, so far as public policy is concerned, we have got to segment public policy under the following categories. Under civil matters, judicial, and then personal matters. So, any transaction or agreement entered into from the point of view of civil matters, sale of office and corrupt influence. Sale of office, you cannot sell the office. An office that has been bestowed on you to exercise certain authorities, you cannot actually sell that office. There are a number of cases. See, so far as the sale of office is concerned. For example, I will just give you the transactions. Supposing a person has been given an authority to just serve as a Muttuswamy versus Swaminatha. And just I remember the case now so that you can tangibly understand. That is why I was just thinking about it, pondering over the case. Muttuswamy versus Swaminatha. In that particular case, it so happened that a peon who was serving in the court, he was about to retire within 6 months. The very next person who is immediately subordinate to that particular peon, this particular peon will come with all the liveries, and they call it as Dawali. On his shoulder he will be wearing the liveries, and he will coming before the judge shouting, please don't shout, and then he will ask them to keep quiet and all that. He will be carrying a mace. Well, that fellow will be there in the court so long as the judge adjudicates the matter and hears the matters by way of judicial proceedings. So this fellow was about to retire. Immediately, the junior peon, subordinate to him, he entered into a contract. Hello, my dear senior, you are going to retire within 6 months. Why not you retire even 3 months ahead of your due date, so that I can become immediately promoted as a senior peon, and I will pay you this much of money if you just retire. You can actually retire, you can actually apply for leave preparatory to your retirement on any of the grounds which is allowable under law. You just, and this fellow also, that is the senior peon, actually obliged the subordinate, his subordinate junior peon, in applying for leave and went on. But under the agreement, this fellow has promised, that is junior peon promised the senior peon to give a certain sum of money. But that fellow never gave. Then this fellow filed a suit. Then the question arose whether this is enforceable. The court said it is not enforceable. Who are you to sell the office? See, you are appointed as an officer. Can you sell the office in order to make some money, quick money and all that? Well, this is opposed to public policy. This is opposed to common law. And this is against public interest of the society and the very office which he holds. So, there is one case. And in another case, in Hiralals, there is another case where a person entered as a member in employment exchange. Now, in that particular case, the employment exchange officer promised him to get a suitable employment for which he received consideration. And then under the agreement, then when he could not actually get him the job within that particular stipulated period, then that fellow actually filed a suit for return of that money. Then they said, no, you cannot. See, this is considered to be opposed to public policy. Any employment which you get must be through employment exchange, and the employment exchange, as per procedure, they should give you the employment. The employment of employee in the employment exchange, he cannot actually receive corruption and grant you and overlooking so many other applicants. Well, that was said. So here you must understand that any sort of this transaction which is otherwise than under the provisions of law is very much discouraged. That is from the point of view of civil matters. Then I will tell you yet another interesting case. I do not remember the case, but however I will tell you the facts of the case. You can remember this. Now there was a particular MLA who was very influential. A person who wanted to get admission in medical college. That is, he wanted to become a doctor, and he approached the MLA. The MLA said, we have got certain quotas, I will definitely give you, but first of all you have got to initially pay so much of money so that I must be able to work upon it. So this fellow received, say for example, he has agreed to receive 50,000 rupees for getting him a seat in that particular medical college. Now it is even more, but anyway, let us now take this example. Now he has agreed to get him a seat for 50,000 rupees. Initially, the fellow who wanted to seek admission in the medical college, he paid 20,000 rupees. And what happened? He could not, that the MLA who promised him to get a seat for medical college admission for his son, he could not get the seat at all. Then what happened? He was evading, he was dodging. I will give you the seat, sir, wait for 1 month, 2 months, 3 months. Finally, everything list has been prepared, in which this fellow who had actually given the money, his son's name has not come in the list. So he filed a suit. This particular person has. Now what happened? That he threatened him. He threatened that MLA, if you are not able to pay back the money, I will actually take up the matter with the chief minister and other appropriate authorities. Then this particular person who was occupying the position of an MLA said, I will give you a promissory note. You just take it. I will definitely give you. Let us actually treat it as a loan transaction. Now that fellow actually gave the parent who wanted his child to be admitted in the medical college. He executed a promissory note in his favor and gave it to him. And when the money was not, even then when the money was not returned, then the parent actually filed a suit against this MLA. See, he has executed a promissory note to pay the money. Then this particular person happened to be an MLA. He said, this is for illegal purpose. He gave that money only for securing a medical college. The court said that is over. See, by executing a promissory note, this has become a loan transaction. Initially, what was considered to be bad in law has become completely different now. You have asked him, all right, I am not able to secure a seat. Let me treat it as a loan transaction. So under section 62 of the Contract Act, it has become a novation. Therefore, what was considered to be legal may become illegal subsequently, as in the case of void contract. But in this case, what happened? What was considered to be initially illegal has become legal on account of novation, a new contract, where he said, I will please treat me as only a debtor and not a person to have received the money. Then the court said this promissory note is enforceable. See, why I am telling all these cases, you must be able to distinguish between an illegal agreement and lawful agreement, which depends upon the facts of the case and the events that are cumulatively taking place with regard to the incident. So that is with regard. Then the next last segment is personal. Any agreement is considered to be opposed to personal freedom, is considered to be opposed to public policy. As I said here, see, immoral, unlawful, which is illegal, which is immoral and opposed to public policy. From public policy, civil matters. And which I have forgotten to tell you one thing is about criminal matters. Judicial matters. On judicial matters also, any matter, any transaction that has been entered into by way of an agreement by the parties will also be opposed to public policy on judicial matters. Now let us actually sum up what are all those instances which are opposed to public policy emerging out of an agreement. Supposing you enter into an agreement with a party to oust the jurisdiction of the court. Ousting jurisdiction and stifling prosecution. These are the two aspects which I have forgotten to tell you. Civil matters and judicial matters. So far, judicial matters are ousting jurisdiction. Ousting jurisdiction means driving the jurisdiction of a particular authority from out of his legal aspect, from out of his legal boundaries. For example, let us actually take one instance. There is a seller. The seller is at Bangalore. The buyer is at Madras. They enter into an agreement that the seller at Bangalore must sell the commodities to the buyer at Chennai, Madras, within a period of 2 months. Now what happened? This fellow actually supplies the goods and then they enter into an agreement. You will find even in the order itself, when a buyer places an order with the seller would have incorporated lot of conditions on the printed order form. One of the clauses in the order form was to this effect, that any sort of dispute between the seller and buyer must be settled only at Bangalore in the Karnataka state. And whether it is a short supply or whether it is a question of claiming damages or whether it is a question of delayed supply, in all matters, any dispute must be actually settled only by Bangalore court in Karnataka at the place where the seller. But what if this condition is there, then is it left open to the parties? No. The Madras purchaser says, no, I don't want that condition. See, we will have Coimbatore as jurisdiction. Let us enter into an agreement. We will enter into an agreement to that effect that if any matters of dispute pertaining to short delivery or pertaining to damages, if they crop up, we will have the court at Coimbatore to settle the matter. Well, this is not allowed. See, it is not left open to the discretion of the private parties to arrange for the jurisdiction of the courts. This is lawful authority under the Civil Procedure Code, under the appropriate law. The matter has got to be decided only at the place where the cause of action has actually arisen. Cause for legal action. Cause of action means cause for legal action. You cannot actually bargain and then finally fix the authority in some other court where that particular court has no jurisdiction at all. So that is what is known as ousting jurisdiction. Then stifling prosecution. Stifling prosecution is entire spoiling the prosecution itself. You cannot actually prevent the court from criminally proceeding with a person. Supposing you cannot actually say a doctor, please doctor, don't come and give evidence in the case of grievous injury. I will give you so much of money. I enter into an agreement with the doctor and not to come and all. Well, that is considered to be stifling prosecution. You are preventing prosecution from being conducted.